Constitution of India under Article 19(1)(a) provides everyone right to freedom of speech and expression to all our citizens. And with this right, one have freedom to make movies, web series and short films to express themselves. But not every right is absolute and it is subject to some reasonable restriction under Article 19(2) of the Constitution. Hello everyone, my name is Satyam Shivaach and I am working as a legal intern at LEXIS and Company, and in this video we will discuss about censorship in the Cinematograph Act 1952. Without further ado, let's start our discussion with what is censorship. According to Britannica, censorship is the changing or suppression or prohibition of speech or writing that is deemed subversive of the common good. It occurs in all manifestation of authority to some degree, but in modern times it has been of special importance in its relation to government and the rule of law. Now, what is film censorship in India? In India, the Ministry of Information and Broadcasting regulates film through Cinematograph Act 1952 by way of constituting the Central Board of Film Certification. The Government of India has vested the authority of censorship, certification, and controlling the public display of film to the Central Board of Film Certification. This way, it was necessary step taken by the Indian film industry as it was growing and the television show were broadcasting and there were a lot of viewers, and to regulate this the act has been made and the Central Board of Film Certification was constituted. Now let's see what are the objectives of film certification. According to section 5b clause 2 of the act provides that the principles which are to be followed by the CVFC while sanctioning films. The guidelines are that the medium of film confers to the value of the society, and the creative freedom or artistic expression shall not be unreasonably curbed. Moreover, the certification must be responsive to social cause, and the film must provide clean and healthy entertainment. Moreover, the film be cinematical of a decent standard and is of the aesthetic value. Moreover, the CBFC must judge the film in its entirety and not from one track biased perspective. Now coming to the board of CVFC. The actual statutory power to certify films lies with the board of CVFC. The CVFC board consists of the chairman and other 12 to 25 members who are appointed by the central government. It is interesting to note that there are no prescribed minimum qualification required to be a member of CBFC, as under Cinematograph Act, the tenure of member is also very flexible and no maximum or minimum tenure is set. The tenure is in fact subject to the pleasure of the central government. The central government can terminate tenure whenever possible on reasonable grounds. The chairman, however, holds office for a period of 3 years only. On exception, the chairman continues until his successor is appointed. Now let's see the function of CBFC. The provision of Cinematograph Act 1952 determines whether a film is fit for public exhibition or not. The CBFC must satisfy this question on the basis of few parameters while certifying a film. There are 4 categories under which CBFC can classify and certify a film. These certifications are as follows. First is the universal. This type of certification is the unrestricted public exhibition, and the same holds no limitation for any age group that may watch the same. They could be family, educational, social oriented theme. This category has fantasy, violence, and minimal foul language. When a movie is being certified U by the board, it must be ensured that the movie is sustainable and suitable for the family to watch it together, including the children. Then the next is Parental Guidelines, that is UA. This type of certification explains the film inappropriate for all age group. However, it is in the interest of the children below the age of 12 to be accompanied by their parents. The reason could be that the theme of the movie may not be most appropriate for the children without the guidance of their parents. Then the next is Adult Only, that is A. As the certificate suggests, this type of film is restricted to adults and adults only. Persons above the age of 18 are adult for the meaning of this certification. The theme may contain disturbing, violent, drug abuse and other related scenes which are not considered suitable for viewing by children who may be influenced by the same negativity. Films that meet the requisite of the above mentioned criteria must not be suitable for exhibition to children or those of age below 18. Then the next is restrictive to special class of person, that is S. This is the last type of certification under the board, and same explain the films which are rated S are meant to be special class of special person. For example, Doctor, if the board is of the opinion with regard to content, nature and theme of the film to be restricted to members of class or person or any profession, the above certification shall given to such films only. Then what are the common reasons for censorship or banning of film in India? In the light of history of why a film has been banned, a part of is censored, the main category for why the same is done are as follows. The first is sexuality. A rigid social structure has been followed in the Indian society. Hence, a medium which portrays sexuality regardless of the audio, written or visual form, which has not been accepted by the society and is concerned a social stigma and is banned on the ground that it might have the effect of undignified morals of India. Then the next is politics. The isolation of political forces is not far when one talks about censorship. The description of an illogical political scenes, directly or indirectly, is banned by the authorized party to it. Overt political overtones are not appreciated by the government and hence is common reason why film certificates are either entirely banned or such scenes are censored or removed. Then the next is communal conflict. Under a series of movies, a nation like India, if a film incites or spur any type of communal conflict, the same is censored. The main aim is to avoid the consensus such as film would have the audience intentionally or unintentionally target. If the state believed that the movie would open a window for riots by a community for the way they have been portrayed in the film, the same is banned by the board or is censored. Then the next is incorrect portrayal. Sometimes a situation arises where a well-known personality objects his own depiction in a medium which would be exhibited and consequently goes for censorship the same. For more clarity, in a situation where the medium is of biographical nature and the person on whom it is based does not approve the authenticity of the same, there have been times where the person has sued for the medium not to be released or to be edited or released upon approval of such person. Then the next is religion. Religion does not appreciate any type of defiance or disobedience towards the values of it professed. Hence, any medium which directly or indirectly distort any aspect of the religion, including its preaching values, idols, to name a few, is highly criticized and therefore censored. Then the next and last is highly or extremely violence. The portrayal of extreme gore or violence may meddle and disturb human mind. Viewing such scene may have a negative psychological impact on their mind if the board is of the similar view that such a scene through any medium may or an underlying negative impact on the viewers. Contrary to the entertainment or knowledge such scene tries to bestow, the same may be banned, edited or censored by the board. Now let's see some of the judicial precedent in the regard. The first is Bobby Art International versus Om Pal Singh Hoon 1996. This case is also known as Bandit Queen case. The Supreme Court, while dealing with the case, held that the freedom of speech and expression under 1901 through Cinematograph Act. The court refused the restriction on the exhibition of the film on the grounds of obscenity. The petitioner contended that the exhibition of film shall be restricted for the nature of depiction of the life story of Bandit, that is Phulan Devi, in the film, and the picturization of rape scene were also questioned, along with the image of Gujar community harmed with some particular scene in the movie. The Supreme Court observed that the film cannot be restricted simply because the content is obscene, indecent or immoral. The abusive language or nudity in the movie was to further the case regarding to depiction of the reality of the life story of Phulan Devi. The movie was provided with a A certificate under Section 5B with a restrictive viewership for adults only. Then the next case is K.A. Abbas versus Union of India 1970. The first instance of doubt arising regarding the censorship clause in India was in K.A. Abbas. In this case, Supreme Court evaluated the practice of censorship of the Cinematograph Act in consensus with the fundamental right to freedom of speech and expression. The fact of the case involved a petition in the court relating to the use certification for a film, which was refused by the board. The interests of the investor were in question. On the guidance of the constitutional aspect of the censorship, the court observed about the censorship of the film is constitutionally valid practice on the ground mentioned in Article 19(2) of the Constitution. It provides a distinction among the film and other forms of art, as a cinematograph has the ability to stir up emotion more deeply than any other product of art. That is all for today's video. Thank you for watching.